Welcome to Dad Talk Today. My name is Eric Carroll, and we have an amazing show lined up for you. We are fighting for fathers all across the United States and all across the world where you can be glad to be dad. Stick around, guys. Dad Talk Today is about to begin. Hey everybody, welcome to Dad Talk Today. It is Monday night. We're going to do a live Q&A. I'm sitting here with Mr. Kevin Hickey. Kevin, what's going on, brother?
Hey, good evening. How's it going?
It's going all right. Guys, we'll be doing our live Q&A. If you got some questions, put them down in the comments for Kevin. Nothing about this creates client-attorney relationship. We're just going to come on here and talk with you. So, Kevin, what's the subject tonight while we're waiting for some of these questions to come in?
I thought we'd talk a little bit about appeals. You never want to get into a situation where you're having to appeal a case, but it happens. And if you've gone to court, you've had your hearing or your trial, and things did not go the way you wanted, or there may have been some mistakes made by the judge, or some evidence that was introduced that shouldn't have been, you may be looking at an appeal. And that is your next step after the hearing, is to try to get another set of judges to review your case. So there's always a deadline. So when your case is finished, you've had your hearing. In a lot of states, and it's this way in Arkansas, usually the judge will tell one of the attorneys to prepare the order. That means the judge will say, here's what I'm ruling, and I'm telling Mr. Hickey or whoever to prepare the order and give it to the other attorney to review, make sure it's what has been ordered by the judge. Everybody signs it, and then the judge signs it, and then it's entered with the clerk. It's filed. So if you want to appeal, you have so many days after that order is entered. So if it's entered on, let's say today, January 17th, in Arkansas, you have 30 days to appeal the case. I've got my dog catcher here behind me. You got 30 days to appeal the case. Be sure and check what state you're in, because every appeal deadline is different. Sometimes there are different appeal deadlines for different kinds of cases. Many times juvenile cases, like if you've had a CPS case that's been opened, or in Arkansas, we call it DHS. Those cases have shorter time frames sometimes for appealing. In Arkansas, I believe it's 21 days on a juvenile case. So you need to be very cognizant of what your deadline is if you think you need to appeal. Appeals are not, you don't want to go into a case before a trial thinking, well, I'll just appeal it. They're not very successful. Usually you have a 10% or less chance of winning an appeal. Courts of appeals really defer to the trial court, and that's mainly because that judge is there, that judge is present, and that judge is listening to the witnesses, can judge the demeanor and the credibility of the witnesses, and is boots on the ground, and can really see this evidence and see these parties and see these witnesses and make a decision. When you appeal it, it goes down. In Arkansas, you'd go to the Court of Appeals usually. That's in Little Rock. And a panel of 3 judges will review your case, and they'll determine if they think a mistake's been made or if something needs to be changed. They are reading a hard, black and white, cold transcript of what happened at the hearing. They are not the trial judge that got to view everything live and see everybody and make credibility judgments. So these judges really defer to the trial courts, because, as I said a minute ago, they're the boots on the ground and got to see everybody and make that initial decision. So when you appeal, understand that it's going to go to some judges that have not seen you or the other party or were present for the trial. They're going to read a transcript of what happened. They're going to look at the evidence that was introduced. and then they're going to decide if a mistake's been made or not. Now, a couple of things about that. You can't normally introduce new evidence on appeal. Sometimes clients say, okay, I want to appeal this. And when we send it down to the appellate court, I want to introduce this piece of evidence and this and this and this that we didn't get to at trial. Normally, you can't do that. The appellate court will just review what was introduced at that hearing. So you got to keep that in mind, and you got to make sure that if there's evidence you want to introduce, that you get it introduced at trial so that you'll have it for appeal if you have to go that route.
What would you say are some of the common mistakes people make when doing appeals?
You mean mistakes that could cause an appeal to happen, or?
Yeah.
Yeah. Usually there wasn't enough evidence to support what the judge did. So, we talk in custody a lot in here about you have to show a substantial change in circumstances since the last time you were in court when you go back to court. The judge may have found that there wasn't enough, that you didn't have enough evidence to change custody. Well, you may think, and your attorney may think, you showed plenty to show that substantial change in circumstances. So you would appeal it and have the Court of Appeals review it. And you're basically saying, here's where we think the trial judge missed their mark. They should have seen this, this, and this. And we think that we satisfied our burden. That's one thing. Other things are when there's an objection made to hearsay or some other piece of evidence, and the judge allows it in anyway. Your attorney may think that was a major error to have allowed that evidence in. That's another reason you can appeal. So there's all different kinds of reasons that you can appeal a case. Nothing's really going to change that percentage, though. You need to understand that appealing is not what you want to plan on doing. They're not cheap. You're going to have to pay attorney's fees to appeal it. You're going to usually have to pay for the transcript that's sent down to the Court of Appeals, which could be hundreds or thousands of dollars. And your chances are, I say 10%, 15% max. That's just research across the board, across the country, as to what your chances are of winning an appeal.
Yeah. I got some questions rolling in here for you. The first one from Dan Fair. He said, what sort of things can be done if one parent is telling the kid she is going to cause harm to the other parent? Is that a crime?
I think it would depend on, I'll go to the last question. Whether it's a crime or not would depend on exactly what was said, how it was said. More than often not. But in Arkansas, we have a crime called terroristic threatening. That's usually when you're threatening harm to another person. So it would depend. But as far as the first question, what sorts of things can be done if one parent is telling the kid she is going to cause harm to the other parent? That's something you have to bring up with the judge. Judges do not like parents talking in a derogatory manner about the other parent in front of the child. And they definitely don't want something like this going on, saying that they're going to cause harm to the other parent. That child does not need to be in the middle of that. They don't need to hear that mom is going to do something to dad. That there's no reason to put that kind of stress on a child or to act that way in front of the child.
Stephen Creasy said, what would happen if you have a court order and paying child support and you get back together with your ex?
I guess you're asking what happens with the child support. A lot of people do, this happens, and a lot of people do nothing, and that order just sits there in effect for months or years, and then they break up again, and it can cause a real problem. So I know it's a bit of a hassle, but if you do get back together and therefore you don't need to be paying child support, contact your attorney immediately and get an order in place to stop your child support, because you don't want that number to continue to accrue with the child support enforcement office, and then that cause problems for you later.
You see that pretty often, people getting back? Not
often, but it happens. And you want that child support to end, because many times we'll be there on the next round, the next cycle, after they've gotten back together for a year or two, then they break up again. And then that order's been in place the whole time. And the child support enforcement agency, they just keep a running tab of what's been paid or not paid. And they show you haven't paid anything for 2 years. Well, the reason was because you were back together. It's a totally logical reason to not pay,
Yep.
but they don't care. Then you're having to try to scramble to show records for what expenses you paid during that time and so forth. So I know it's a bit of a hassle, but go back to the attorney you had and get the child support to stop.
Yeah. Hey, so another question, Kevin. Did you get any of that blizzard that we had yesterday?
Yes. Was that yesterday or Saturday? I think we had it Saturday.
Yeah, we had snow falling yesterday. It didn't stick.
No, it didn't really stick here. We got 2 or 3 inches, I think. We weren't supposed to get that much, but boy, it came through here. And it was beautiful, and it was just a little too warm to stick.
Yeah. I don't know what it is about living here in Georgia, man. The second somebody sees a snowflake, you won't find a gallon of milk or a loaf of bread anywhere.
Yeah, that's it here, and the running joke is, does everybody, and I think I saw you posted something about that, and the running joke is everybody going to make French toast? I mean, what's going on? Why you need bread and milk?
I don't know, but I'm hoping each and every one of you made it safe through the snowstorm yesterday. But we got another question from Mr. Eddie Valencia. He said, I put myself on child support in order to see my son, but his mother refuses to tell me where she moved to and where his daycare is located. She will only allow me to pick him up at a random park on her terms, or she just won't let me see him, period. Any advice on what I can do in order to see my son? I made over 26 police reports because she refused to take him to our pickup location, her home, and just keeps him, but nothing ever happens, even in court when we went back.
Eddie, I'm assuming you have a visitation order. I didn't see that in here. I saw where you said you put yourself on child support. I'm assuming that means you had it put in place through a court order, but I don't see anything about a visitation schedule. The visitation schedule needs to be ordered, and if you don't have one, you need to file to get one. That'll avoid a lot of these problems. 26 police reports because she's refused to go to the pickup location is way, way excessive. And she clearly thinks that she doesn't have to comply with it. So if you have an order in place and she's not following it, it may be time to file for contempt.
Michael Neal said, what about one parent refuses send son to school and don't communicate with other parent with a court order? I guess
I'm wondering if he's talking about COVID, not sending the son to school. I need a little more info on that one.
Yeah, get it back to that, Michael, and I'll definitely get that back up. Lex H on YouTube said, what are your thoughts on Supreme Court Justice Kavanaugh's comments describing the best interest standard as ambiguous and capricious? I agree with his assessment.
Ooh, Lex, I'm not sure on that one. I don't know that I've read that. And I don't know if he's talking about best interest standard for custody. So I'd need to know a little bit more about that. I mean, I don't know. You have this best interest standard in custody cases. We can just talk about that for a second. Yeah, what does that mean? It's going to be different in every case. What's in the best interest of the child and what should happen. But you have decades worth of case law that in every state that define what best interest of the child is and give you an idea or a roadmap as to what's best. But it's going to come down to the facts in your case, and it's a case by case basis. And the judge comes in and sits down, preferably with a clean slate, to listen to what you're presenting on the day of that custody hearing, and whether the best interest standard. And the best interest standard is going to be applied, and depending on the facts that are shown, the judge is going to make that determination. So I know it may be a little vague or sound vague, but it's hard to micromanage it much more than that, because you're just going to you've got to leave some discretion to the judges that are listening to the case that's in front of them.
Yeah. Aaron Anderson here on Facebook said, I'm currently going to court here in Alabama to get my son's mother to start paying child support and limit my son's exposure to her boyfriend. who has been convicted of shooting someone. I've got a two-part question. When will the court do something besides adhere? My son has came home from his mother's with girls' underwear on. Will that also affect limitations onto her visitations?
I've got to. When will the court do something besides? I don't know what that is.
I think he just meant to put adhere. I think the ad.
Okay. Well, I mean, that's all you can do is try to have the judge see what's going on with this guy. I don't know on the coming home with the girl's underwear on. I mean, I don't know if this is related to the boyfriend, if he's interacting with your son and causing these problems or what. But that's one of the biggest things that comes into play when we look at a change of custody. Usually there's been a divorce in the past and custody was determined, and then one party decides they want to come back to change custody. Many times it's because the other parent has now got another significant other in their life, and that person is not a good influence in the home, or they're creating an unwholesome environment in the home, and we've got to look at doing something to change custody. So I think I get the gist of what you're asking, and I think you're on the right track. If this guy is definitely a bad influence, your son's afraid of him or whatever else, that's something you're going to want the judge to know. And I don't know how old your son is, but if he's old enough to testify, he can. Or you may want to get an ad litem involved and have him talk to the ad litem about how he feels about this, the new boyfriend.
Josh Johnson has said, if my son's mother is on probation for domestic violence and a no contact order imposed by a judge, and she violated that no contact order, what rights would I have as far as getting my son? I pay child support and establish paternity. Long question. I apologize.
I paid child support, and so he's gotten a paternity established then. I think part of that would be who the domestic violence was against. She's got a no contact order. I wonder who that's against, because if it was against him, normally the child, you'd be able to get custody in that situation. All of those things are something a judge is going to want to know about, Josh, if you file for custody or some kind of emergency custody because she's violating the no contact order. That's something a judge is going to want to know. Domestic violence is not to be trifled with, and judges do not want that kind of behavior going on around children. And so that's something you definitely want to bring up.
Josh, if you don't mind, clarify for us who that no contact order is against. I'm just kind of curious.
Yeah, that'd help too.
Yeah. Michael said mom tells school that the child has COVID symptoms when they don't, and is also refusing visitation.
Okay, that's what I was wondering. Yeah, on the COVID deal, we've had problems with that with custodial parents saying that there's COVID symptoms or whatever, and they with the child, and they don't want to comply with visitation and don't want to comply with taking them to school. The biggest thing is getting your ducks in a row and getting that proof, either getting the child tested or some other way to verify that the symptoms are not there and the child needs to be going to school. I don't know what state you're in, Michael, but in Arkansas, the Arkansas Court of Appeals came out fairly soon after the lockdown, 2 or 3 months after the lockdown back in 2020, and made it very clear that you do not use COVID as a reason to stop visitation, even though that became a very popular tactic for some parents to stop visitation. Well, they've got COVID or there's a threat of COVID, so it's just too dangerous. No, the other parent has rights, just as much rights as you do, to see their child, and visitation needs to take place. So if that continues, or if it's been going on for a while and she's just not complying, then you may have to file some kind of contempt.
Yeah. Steve here on YouTube said, false protective orders are a huge problem and probably the most abused process in the system. Why do judges have so much authority and appear to be biased towards men?
They want to err on the side of caution, Steve, and that's not an answer anybody really wants to hear, but they would rather put a dubious protective order in place, restraining order in place, than deny it. And then there was some credibility there to the allegations, and something happens to the person. And it ends up a lot of protective orders probably get entered that are very iffy. But that's, you're asking me the question. That's the best answer I have, is that judges want to err on the side of caution. And if they think there might be something there, or there's a chance that there is, they would rather enter the restraining order than not enter it and something really happened to this person.
Yeah. I think to the second part of his question, it's crazy. I won't mention his name, but I was talking to a police officer not long ago and asking him about these domestic violence situations. There's several of the times that they'll call saying, hey, she hit me. And then they show up and they arrest him. And he was like, it sucks so bad because we know that he's telling us 100% the truth, but we have to act on it. I think these are some questions. There's definitely some of that there, Steve. And I'm sure both of us probably wish we had a better answer for that.
Yeah. And why you ask, why do judges have so much authority? It's either a judge or a jury. And on orders of protection, they come up a lot, and we just couldn't have a jury trial on every one of them. And so judges are the ones that are generally appointed to handle those. And it gives them a lot of authority, and they get to make that decision.
Mark Esquibel on Facebook said HR 1470, 117th Congress Ending Qualified Immunity Act. I guess that's going through right now. He said, if passed, do you think it will curb judicial corruption? I'm sure I don't know if you've gotten a chance to look at that or not, Kevin.
I have not, Mark, but let's try to look at that for next time, and maybe we can have more of a discussion about it. I would have a hard time. It says Ending Qualified Immunity Act. I'd have to see. I don't think any, immunity for government agencies will ever go away completely. You just couldn't operate. But yeah, I'm definitely interested in looking at it.
Yeah. Chuck Smith said the DSS worked taunted me at the grocery store. I think he meant worker.
Worker, yeah.
Said I don't deserve my kids and I was a deadbeat and they would be better off in foster care. I reported her, though, the DSS executive director, my senator's office, my governor's office, my congressman and local representative's office. Can a DSS worker lose employment for unprofessional harassing behavior? I just left the grocery store to avoid the conflict. It is awful what these social workers get away with.
Absolutely. A caseworker could lose employment for being unprofessional or harassing. And that is totally unprofessional that she approached you in a grocery store like that and said those kinds of things. That is totally inappropriate. She should not be talking about your case unless you're in court or in some kind of setting where you're supposed to be talking about your case. So absolutely. And I think you need to take whatever action you need to make that known. I'm assuming you have a court case that's still going on. At your next hearing, I would be bringing it up. Make sure your attorney knows about it. And if you have a caseworker that is not handling your case properly, that may need to be brought up to the judge as well. So you need to definitely need to take action on that.
Josh re-clarified. He said the no contact order was against her. I guess he's saying the no contact order was against the judge.
No, it was against mom, I guess is what he's saying, isn't it?
Now I'm confused again. I've seen some of that lately, so that's why I was asking, man. But I guess you can.
Well, if Josh filed one against her and it was granted, and now she's violated it. I mean, if he filed it against her and she's not supposed to be contacting him and she's violating it, I mean, that's a problem. It's a real problem. And I think Josh is the one that was asking about, could he file for custody or something, but that's something you definitely want to look at.
Mo Smith said, I have 2 girls, 1 boy. Ex only wants to pick up the girls and always leaving my boy. Do I have to send them if she will not take all 3?
Mo, that's a really good question. And this comes up where sometimes we get these situations where a parent will only have visitation with certain children. Yeah, you still have to send them. You've got a court order to make children available for visitation, and that's all you can do. You can't force her to exercise the visitation. Can't force her to pick them all up, but you do have to make them available. And what I've done in the past, if that's going to continue and it goes on for a while, and they make it clear they're not going to take all 3 children, we've gone back to court to have their visitation modified and taken away. And then you look at modifying child support in that situation, because now you have a child that's with you more time, because when you entered that first child support order, it was presumed that the non-custodial parent was going to get all 3 children for a certain amount of days. Well, now that's not happening. So you, in theory, have more expenses because of that. So that's something you'd want to look at too.
Ed Gelden Highs said, to follow Steve's comments, how do judges justify issuing those same emergency protective orders, especially after false allegations just got dismissed? Does that qualify as perjury? I think it's a great question.
It is a good question. It could be perjury. But where these things fall in a lot of times, you've got 2 people that had some kind of altercation happen. She says he hit me. He says she was coming at me and I pushed her. Well, both of those things could be true. If you pushed with a certain amount of force, it might be a hit. And to her, it might have been a hit. Or you could be lying about what happened. She could be lying about what happened. So, a lot of these things come down to factual differences, but on how people observe what happened in the altercation. And, everybody says, oh, I've got an eyewitness. That's great. We love having eyewitnesses, and we need witnesses at trial and stuff like that. But eyewitness testimony many times is not your best evidence. People remember things differently, see things differently, and sometimes they just blatantly lie. So, you're talking about here, it says after false allegations just got dismissed, justify issuing those same APOs. So I'm wondering if this means another one was filed. Is that what you think, Eric, after one was just dismissed?
That's what it sounds like. I mean, you hear these guys that come in here all the time about like 20, 30, 40 different protection orders. And it's like, at what point do we say there is a pattern going on here and we need to put a stop to it?
Well, at some point, especially if you're coming in front of the same judge, if I'm representing you at that, if we're defending that and at that order of protection hearing, I'm going to be bringing that up. I'm going to have her on the stand and be saying, ma'am, isn't this the 17th time you've tried to get one of these and they've all failed? Isn't that correct? I mean, you want the judge to know all of that. And if it's another iffy case, I don't think the judge is going to grant it. There's a lawsuit you can file and it's a cause of action called abusive process, and it's falsely bringing agency's actions against somebody's, and it's usually filing a false police report to get them arrested, trying to have a prosecuting attorney bring charges against somebody, falsely. After a while, you should be able to, if you want, no one wants to have to go to court, but you could sue her for this. I mean, it could be defamation, but it's definitely abusive process. You got to do something to try to put an end to it.
I think that needs to happen. We need to see more people trying to hold them accountable for these false allegations.
Oh, absolutely.
Yeah. Cindy Slavin said, working on 3 cases involved with parental alienation. Unfortunately, these guys need to get attorneys, which they can't afford. Whereas the baby mama goes to legal aid. Dads can't afford lawyers. System is unbalanced. How do we begin to elicit changes so men get equal rights? It's an ethical case with that social worker. she violated his confidentiality?
I'm not sure on the last couple of sentences there, but I hear you, and it does seem unfair. I mean, a lot of times the moms will go to legal aid and they get help. Our legal aid office here, locally where I am, you have to show that there's been some kind of domestic violence before they will, or some kind of altercation before they will help and assist. So I think that puts a little bit of a limit on it. But it's true, dads oftentimes are lost in the shuffle. Now, legal aid is usually supposed to be available for men just as well as women. So I don't know about your situation, but you can try checking it out. But we're trying to do all we can to try to equalize the system and make it not so unbalanced, so that men can start to be on a little bit more of a level playing field. We've got shared parenting and that kind of stuff. And, it's not like turning a go-kart real quick. It's like trying to turn an oil tanker. I mean, it's really takes time to try to get change to come across.
Yeah, I think that you get so many different areas where it comes to pop culture, the way men are viewed, the laws, and it's been this way for a while. So like you said, overturning that's going to take some time, but doing what we're doing here, I think, is definitely one of the ways that we can do that.
Raising awareness. Absolutely.
That's it. Chuck Smith, I'm going to read these comments real quick, get your thoughts on this. He said, it is an appellate court and the guardian ad litem judge have been removed. DSS got pulled from my case because there was no abuse and false allegations. They are upset they got exposed and continuing their harassing behavior. Thanks, Kevin and Eric. My attorney has got this guardian ad litem judge have already been removed. You guys are an inspiration. He followed that up by saying 840 days in accounting and the alienation continues and reunification gets impeded by mom because she says they are scared, but the experts say they are alienated and going to testify to that. It's just sad what they allow the abusers to get away with. I would think if the experts are going to testify to that should hold some weight, don't you think?
Yeah, Chuck, you've had a long road, man, and I hate that for you, but it sounds like things are headed down the road that you want, and you definitely, if the experts are identifying the alienation, that is huge, and you want them to come in. You want them to come in and explain to the judge what alienation is, why it's harmful to the kids and the parent that's being targeted, and how to fix it. And it sounds like you're on the right path. Hopefully your hearing's coming up soon and you can get some finality.
Yeah. Josh re-clarified down here. He said she is on probation for domestic violence and negligence assault. The judge imposed the no contact order. I refused at the time to press charges, provide a statement. The state picked it up, but she has violated the order several times. Child alienating is an epidemic. I hate to hear that, brother. But thank you for clarifying that.
Yeah. Yeah. And many times I think he says he didn't press charges, but many times when you get arrested for domestic violence, when you bond out, a bond will be set, the amount of money you have to pay to get out of jail. And on domestic violence cases, they put what's called bond conditions on it. So they will, in addition to paying the money to get out, they will say you can't be around so-and-so, you can't be at their place of employment, you can't be at their home. Those are conditions that are also part of your bond. Showing up for court, you can't violate it. So that may have been part of what the no contact order was. He said the judge put it in place. I bet that's what that was.
Stephen Creasy said, I went to court and got a court order for every other weekend with my daughter, and I've been paying $354 child support, $81 a week. Could I have my child support lowered? The judge never said anything about it.
It depends on your income. Anytime you want to look at modifying child support, you have to look at, has there been a change in your income? Has your income gone down? Has mom's income gone up? I mean, every state's different how they calculate child support. So you'll want to check on the state where you live. And if you've had a big difference, change in income, you may want to get a consultation with an attorney and talk about it.
Yeah. Steve on YouTube said, at what point does filing protective orders over and over again become harassment? I think you touched on that a second ago, but.
Yeah, I mean, To me, it depends on the time frame. Are they happening fairly often within a not too long of a time frame in between, and they continually get denied? I mean, if that's the case, 2, 3, 4, to me is enough. If that's happened 2 or 3 or 4 times and they've all been denied, I think it's harassment. I think it's legal harassment and legal litigation abuse, and it can go back to this abusive process we were talking about. And at some point, some people just don't get it doesn't get through to them that they've got to stop that behavior, and you just have to file a lawsuit to get their attention. And you may be at that point.
Yeah. Stephanie Ann said, "Is there something like this for moms?" I just wanted to clarify something
right here.
This is it. Even though this is called Dad Talk, and I really, with this program, we're talking about trying to change that culture of the way that men are viewed and some of the challenges that they go through. But I think we have moms that comment in here all the time, and you guys you ladies are more than welcome to join in if you got some questions. That's what this is here for. We're talking about equality. We're here to fight for parents and their relationships with kids. So always feel welcome to come in here and bring any questions that you got. We're in this thing together. So
absolutely.
Mark Basler said, on tonight's appeal topic, I had a very biased judge on back child support. The ruling was only $3,400, and it was going to cost me $3,500 for the appellate court entry by a lawyer. But I was to have this judge for a few more years for his rotation. Everything was laid out very well in court. The appellate court sent the decision back to the judge for further review, helped letting the judge know I was serious by getting his hand slapped early in his cycle. I was curious your thoughts on that, Kevin.
That's true, Mark. And I always tell clients their chances, and that, this is not I don't want you to think this is we're going to file an appeal and win. Yes, the judge made some mistakes, but that's not always enough to win. So, I was talking kind of negatively about appeals. That doesn't mean that you shouldn't. There's sometimes that it's an issue that you want to fight. It's a situation that you feel like needs to be corrected, or at least, brought up. And I call it sleeping well at night. Sometimes clients just want to be able to sleep well at night, knowing they've done everything they could. And if they think something was really wrong, and they're not going to sleep well at night unless they have someone else, an appellate court, review that decision, then do it. If it's within your budget and it's going to make you feel better to push that and try to get that changed, then go for it. You just have to work closely with your attorney, really listen to what the attorney has to say and on your chances and what kind of arguments you have. And, that is your right to appeal a decision. It's absolutely your right. So, and I'm glad. It sounds like what happened to you is what's called a remand. It went up to the appellate court, and then they remanded it back to the trial court to review what happened. And they sometimes will give directions on, here's where we think you made a mistake and what you need to do this time. So hopefully that'll turn out good for you.
I think this is going to bring on a little bit of a conversation here. I want to say a thank you to this guy right here, Mr. Philip Kemp. Met him when I was in Tennessee a couple of months ago. Took us out to supper. Appreciate the support. But he said, if trial by jury is inviolate, why can't you get one in family court? Thus, if there is no due process of law, then all orders issued are unenforceable, correct?
Not all. Yes, there's a constitutional right to a trial by jury initially. And the reason that's put in the Constitution and the reason it's there is for when you are usually for criminal cases. That's where that right really comes up, and you always have that right to a jury trial in a criminal case. Somewhere along the way, there were rulings that said that not all legal cases needed to go to a jury. The states have the authority to have certain things heard just by a judge. And so that's why a lot of family court matters and other kinds of matters can be heard just by a judge without a jury. Now, I will tell you, there's a couple of states, Texas is one of them. I'm not sure the other one, and I think there may be more than two, but where you can still get a jury trial in a divorce or a custody case. And that is very, like I said, most states don't have that, but some do. So But that's the state's decision whether to allow that procedure or not.
I'm Googling. Googling is like, I guess, your best friend. From what it's telling me, that Georgia is one of those states.
There you go. There you go.
How about that? Didn't know that, but I wanted to bring up a conversation about that. What are some of the advantages and disadvantages of those jury trials? And do you think that we should have jury trials in all states with family court?
It depends. Jury trials are not, they're not without their costs. I mean, every juror has to get paid. It's not a lot of money, but there are administrative costs involved. The clerks have to be, it costs money to have a jury trial. You have the clerks that are involved to draw out the jurors' names. Jurors are having to miss work. A jury pool here locally in my county could have 70, 80 people in it. And those people are having to miss work at least for part of the morning, if not the whole day, depending on if they get on the jury or not. They take longer, which means that there's going to be more resources involved as far as the courthouse and that kind of thing. You're going to use up more courtroom space, more days. So there's a lot more. It costs more overall to have if you had a jury trial on pretty much everything. Some of the reasons you may want a jury instead of a judge is depending on the judge that you have. If you have a judge that you feel like doesn't make rulings that would be helpful for your kind of case, then you may want to have a jury look at it. You may have a client that's very likable and would come across very good to a random group of people, a jury, and much more than the other side. And so you'd want to have a jury for that reason. Vice versa, you might have a client that you do not want to put in front of a jury just because of their personality or whatever. So there's always a lot of factors involved as to why you would ask for a jury or not a jury. I just think that it would be, I'll tell you another thing, your attorney fees are going to go way up. People complain about attorney's fees already. Your attorney fees are going to go way up if you're having a jury trial and everything, because there's a lot more preparation involved.
Yeah. Well, guys, we're caught up on the questions. So if you got some questions, put them down there in the comments. We're getting a lot of comments about situations that they're going through. I see one I'm going to bring up right here from Eric Carroll on Facebook. Kevin, let me ask you a question. So what are some of the things, a lot of people have bring some of the trials that they've been through, especially when it's coming with, family law attorneys. What are some of the things that you think that attorneys could do better when dealing with their clients in family court?
I think communication. I think there's a lot of, and I think we've talked about that on here before.
We have.
I think there's a very big disconnect between what an attorney's doing day to day and what their client thinks their attorney is doing day to day. And I think when days and weeks go by with no activity, a client can start to think that their attorney's not doing anything for them. And that's just, at least with our office, couldn't be farther from the truth. It's just a lot of times, a lawsuit is not a car going down the road at the same speed with things happening regularly all the way until you go to court. It's a lot of hurry up and wait. You send out discovery and you're waiting 30 or 45 days before you get answers. There's nothing really to do during that time. And I can tell you as the attorney, I don't want to do anything during that time. I don't want to, needlessly waste your attorney's fees if you've paid me a retainer. I want to save that for the big battle. I know it's hard for you to come up with that money for a retainer to pay us. I want to make sure I'm using those dollars in the best way for you. So I don't want to just be randomly doing things just to show you that I'm busy. But I don't think clients understand that sometimes, and it's not their fault. They aren't part of the legal process every day. So right. I think communication is something that attorneys could do a lot better. We could really let our clients know a little more often, maybe, hey, we hadn't forgotten about you. We just got some downtime in your case. And, and I think that's where some dissatisfaction comes in. It's like, hey, I just wrote this big check to this guy and I hadn't heard from him in, a few weeks.
Right.
Well, we might have gotten everything filed. We're searching for your ex because they're avoiding being served with papers. I mean, there could be a lot of things going on, but I'm not going to call you every time something like that's going on. And, we're working on it and moving your case forward. But we don't always communicate that very well.
Yeah. And I know, guys, sometimes when you tune into the show, you're going to hear some of the same things that we're going to talk about that we may have talked about in previous weeks. You never know when somebody might be tuning in for the first time and they never heard this and they need to hear it. But I got a flip side to that question before we go into this, because you covered this just a couple of weeks ago. On the same token, what are some of the things that you think the clients can do better to help the attorneys better fight for them? I know you mentioned one time giving the full side of the story and not finding out details when you're mid-case that you'd never heard before. And I would like to say that some things I don't think the community gets to see sometimes. I've seen that happen several times, that mid-case an attorney finds out some information that was very critical that doesn't so much go in their favor. And they're like, what am I going to do with this?
The confidentiality rules for attorneys and clients are there for a reason. And we cannot disclose what you tell us in a consultation. We just can't do it. And the reason for that is so you'll be open and honest with us. Now, when you come in to hire us, we understand we're strangers. We don't know each other. And so you don't want to talk about your deepest, darkest secrets. I understand that, but it would sure be good if you could get over that and tell us everything. Because if I know this bad fact that's out there that you're worried about, I can prepare for it. And when we talk about it in my office, it stays in my office. Now, that doesn't mean that your soon to be ex or the other parent doesn't already know about it and plans on using it. Well, if I know about it ahead of time, I can prepare for it and possibly even minimize it. And many times it may not be as big of a deal as you think it is. It may not be as big of a problem for your case as you think it is. If I don't know about it, I can't help you with it. And the last thing you want to do is have me find out about it by surprise, like Eric was just talking about, either in the hearing or whatever, because then I'm really scrambling, trying to figure out what to do about it. And whereas if I'd have known about it weeks ahead of time, or even a few days ahead of time, I could have gotten a plan together for when it came up, how to handle it. So those confidentiality rules are there to really help you be open and honest with your attorney. And I know it's somebody you don't know, and it might be an embarrassing fact or whatever, but the more we know, the more we can help you, because more than likely it's going to come out. It's going to come out, and we just need to be able to be prepared for it.
Yeah. You're paying these guys to fight for you. If they don't have all of the pieces of the puzzle, it's hard to put it together. So,
well, and that's it too. Don't pull punches with your attorney about what you want. If there's something you're wanting in your case, tell your attorney. They work for you. It's not the other way around. And it still surprises me, and it shouldn't, I don't guess, how many people come in and they sit down and we start having a consultation, and I'm taking notes or whatever, and they apologize and say, I'm sorry, I'm so nervous to be here. I'm so sorry. And it shocks me. It's like, why are you nervous? But then I have to put myself in their shoes, that they're never in front of an attorney all the time. I do this stuff every day.
right.
But so I know it can be hard, and I know it can be very nervous to go talk to an attorney, but you got to understand, we're in this business to help people. We're in this business to help you. I'm on your side. So I know you may be nervous, but you tell me everything you're wanting to know. You tell me everything you're wanting to ask for, and then let me work through it with you. And I'll tell you what things we can ask for and what we can't. That's what I'm there for. And so try to get over the nervousness and talk to your attorney about it.
How dangerous is it for a client to try to take matters into their own hands, like contacting the opposing attorneys or the guardian ad litem? Because I've seen that happen as well. And then people will reach out to me and be like, hey, this is what I did. I contacted them. I recorded it or something like that. What do you think? And my first thing is, well, did you tell your attorney you was going to do that? No.
Two or three times a year, I get this email from a judge from somewhere. Mr. Hickey, or it's the other side. Their client did it to them. Mr. Hickey, we just got an email from your client asking why this hearing hasn't been set or whatever. Do not contact the judges. Do not contact the other attorney. They can't talk to you. It's an ethics rule. When you're represented by an attorney, the other attorney can't talk to you. Go to your attorney with questions. People want to they've heard this old phrase, the squeaky wheel gets the grease.
Yeah.
That does not apply to your case. Don't think that, well, I'm just going to call the clerk. I'm going to call the judge. I'm going to call the bailiff. I'm going to call everyone. No, that is going to do nothing but alienate that judge from you and put a bad taste in their mouth about your case. Talk to your attorney and go through your attorney. There's other things too. Do not go on social media trashing the judge, trashing anybody else in the court system or whatever. It will get back to them. Don't go on there trashing your ex. The other side will get it. They're going to use it. And, I tell people, don't text anything or put anything on social media that you would not be okay with seeing on a big screen at court, because that's where it'll end up. And if you're going to be embarrassed by that, then don't text it, because when you're sitting there in court next to me and it comes up there 10 foot by 20 foot up on the screen and you're embarrassed, it's too late. It's too late at that point. You can't take it back.
How much, what's the percentage of evidence nowadays that is social media postings and text messages?
I could not give you a percentage, but I will tell you that it's every case. And whereas 15 years ago, it was 1 in 10. Now it's every case. There's at least a text message, email, social media, one of those things or a whole bunch that we're using every case. Yeah.
I'm going to get back to your questions now, guys, but somebody needed to hear that tonight.
Absolutely. Absolutely.
Yep. Jeremy B on YouTube said false DV arrest in 2018, null prost in 2021. The other parent continues false DV claims during divorce. Could the dismissed domestic violence charges still affect the outcome of the divorce?
Yes. If you're asking if it can help be in your favor, Jeremy, your attorney needs to bring all of those up and show why they were dismissed and show what she's been doing. Yeah, that's a common alienation tactic.
Yep. Mark Kennedy said, I have paid FRO in Ontario, Canada from day one, and the judge said I could have contact with my son April to February, I guess 2020. The mother took off to Russia illegally against court, or see more. X only. Huh.
What in the world?
I'm not too sure. I'm not sure what happened there, Mark, but if you will get that back down there, I will definitely take a look at it. Harrison Morta said, how do you raise your son when he starts getting those weird thoughts in his head by those liberal nuts? Well, not so sure about that one. But anyway, what would you say in approach? There's a few more people that was talking about the communications with attorneys that we was talking about. If there is somebody that doesn't feel like their attorney is communicating properly, how would you suggest they reach out to them and address that?
You need to set up an appointment and go talk to them. You need to just call, set up an appointment, sit down with them and tell them, I don't feel like I'm getting good communication. I don't feel like I know what's going on in my case. Where are we? Are things going well? Chances are that things are okay with your case. It's just going back to what I was talking about, this not so good communication. So, but set up an appointment and go sit down with them.
Yeah. I guess that's it for right now, Kevin. I mean, let's talk a little bit more about those appeals. Is there anything on that you didn't cover?
It seemed like there was something that I had intended to bring up, and I've forgotten it now. But, one of the things we talked about a minute ago was a remand. When you do appeal your case, the Court of Appeals has at least 3 options at their disposal. One is to affirm it, which means they review it, and they're saying there's not enough there to change what the trial court did, and that decision stays in place. The other one is remand it. They send it back to the trial judge and say, we think you made an error here and here. Here's what you need to do. You need to have some other evidence presented to make a child support determination or whatever it is. The other thing is a reversal, where they say, judge, let's say custody, for example. You changed custody in this case. That was a clear mistake. We're reversing that, and we're putting it back to the way it was before you made this decision, and it's over. So that doesn't go back to the trial judge. It's just over at that point. So the Court of Appeals can do all of those things. And, you're going to get any of those three things happen whenever you appeal your case. So something, that's the results that you're going to be looking at.
Yeah. So, I mean, I probably could have left some of that out in that last comment, but I see what the viewer was talking about here. And I know this is an extremely sensitive situation that's going on nowadays, but we're starting to see more and more of it, where it seems like transgender issues are being brought up, especially with young kids, and there's a parent that disapproves of it. And, if there is a parent that disapproves of it and feels like this is something that, they don't want their child going through, like, have you had to deal with one of those cases yet, Kevin? Or do you have any advice of parents and what they should do with something like that?
I had a case where we had a teenager that was identifying as he'd been a boy and was now identifying as a girl. I want to say he was 17 or so, wanted to change his name. And the other parent, they were divorced. And the other parent had not been real involved the last few years. And so didn't really put up much of a fight because the child wanted to change his name to a female name. And excuse me. So it ended up not being contested. So we didn't really have a hearing, and I didn't really get to see what the judge would have done with that. That is an area that is so brand new, and there's so much gray area because there's so many constitutional rights involved. It's hard to say with certainty where that's going to head. And you get two parents that are opposed on whether that should happen or not. I don't know what a judge is going to do with it. I would not want to be a judge trying to decide that case.
Yeah. Steve Avery on YouTube said, curious to why in Michigan they changed judges prior to divorce being final. I was told this is common practice.
I guess he's saying they have one judge and then right before the final hearing, they switch it to another judge.
What it sounds like to me. I haven't heard that one before.
I don't know why they would do that. Normally courts want to keep the same judges on for the whole case, or if there's a reopen, custody's to be changed a year or 2 or 3 years later, they want the same judge. They feel like a judge that's familiar with the original case will be much better to hear a change in custody or whatever issues come up in the future. So normally they want that continuity of judges. So I'm not sure on that, Steve, why they would want to do that.
Yeah. All right, guys, it looks like we have made it to the end of the episode. You guys need to be, I guess we will have some updates coming up very, very soon on the trial of Jim Brashear. Kevin, do you have any updates on that or anything new?
I talked with the family a couple of days ago, and it is still set for the week of March 21st in Lewiston, Idaho. I'm going to be there. I know, Eric, you're going to be there. We're there for support, to support the family. And as far as I know, it's still going forward on that date. Now, there is a pretrial conference coming up February 2nd or 3rd, so we may have more information then.
Kevin, it's, I think, just a few weeks away. We're going to be at the 1-year mark of this happening.
Yeah, I know. And I can't believe how fast it's gone by. It doesn't seem like that long. In ways, it seems like so long ago and then not so long ago. It's strange.
It really is. But guys, we will be covering that. I think I might be covering that on behalf of the John Mast Foundation. If that happens, I'm going to be letting you guys know about that. But we'll let you know more about that as it gets there. But Kevin, if anybody would like to get your services, maybe they want to know a little bit more about parental alienation, find some of those resources, where can they reach out to you?
A lot of what I do, we haven't really talked about that, but about 80% or more of my practice is divorce and custody. and I handle a lot of high conflict custody cases. And we handle I'm based in Arkansas. That's where our office is, but I handle high conflict custody cases all over the country. If you have a case that you think we might can help with, reach out and contact us. And what we do is we get admitted to practice in your state for your case and work alongside your local attorney. We just have a lot of experience in high conflict cases that deal in parental alienation, false sexual abuse allegations, anything along those lines. That's kind of what we do and have experience in. And we've handled those cases in several states. Again, my office is in Arkansas. Our office number is 479-434-2414. That's 479-434-2414. And you can set up an appointment. They will probably want to charge you a consult fee. If you tell them that you found out about us on Dad Talk Today, we'll waive that consult fee. So be sure and tell them that, and they'll waive it. Our website has a lot of information, www.kevinhickeylaw.com. If you go there, as Eric was talking about, we have a lot of information on parental alienation, false sexual abuse allegations, CPS cases, a lot of good free information there to help you with your case.
Yeah. I might be speaking out of turn here, Kevin. I'm not too sure where that's at right now, but Cindy Slavin said, do you do cases where guys can't afford to get an attorney? I know at one point in time you was talking about trying to put together a course or something to help.
No, we don't. Cindy, that's essentially a pro bono case. We really just can't do that. We're not set up for that. We're hoping to have some resources through, I hope, Eric, it's okay to mention the John Mast Foundation. Yep. At some point we're going to try to get some resources there on the John Mast Foundation website to hopefully help some people that can't quite afford to get an attorney.
Yeah. You guys, as soon as we can get that updated and get it out there to you, we will. Make sure you go follow that over on Facebook. We've been posting some updates and trying to get some stuff going out. And a few people said thank you for tonight's show. They learned a lot, guys. We'll be back in 2 weeks. Join us again here in about 2 weeks, and we do this every 2 weeks on Monday, and we will love to answer your questions. But until then, Kevin, I appreciate it, my man.
Thanks, guys. Good night.
See you next time. Hey, everybody. Eric Carroll here. Thank you for tuning in to another exciting episode of Dad Talk Today. While we fight for you, we would ask for you to please help fight for us. Like, subscribe to our channel, and ring that bell so you get notifications every time we go live. There's also Super Chats, patreon.com/DadTalkToday, and other ways you can support our channel. Thank you for being here, and we will see you next time.